Judge, thank you very much, and we know the duration of the trip makes it a special sacrifice for you to be here, and we certainly appreciate you, your family, and friends who are in attendance for making that sacrifice. I'm going to start the round of questioning, 5 minutes for each member. Ms. Hill, most members of Congress who have tribal representation in their states understand this whole issue of tribal sovereignty and the fact that you could have served as Attorney General for the Cherokee Nation. Could you summarize in a few sentences the difference or the challenge that you faced with that responsibility?
Serving as Attorney General of the Cherokee Nation, is post-McGirt especially has it's been very challenging. There's been a great increase in the number of criminal cases that are being heard. Indian tribes have jurisdiction over crimes committed by Indians across their Indian country. So throughout the reservation of the Cherokee Nation has jurisdiction, and the Office of the Attorney General is responsible for prosecuting those. So as the Attorney General, it has been the responsibility post-McGirt to scale up that office in a way that so we were able to handle all the different cases that came to us. And I think that that's something that for people who have Indian country in their districts are probably more familiar with that process. It may not be that familiar to other people. So
your responsibility as district court judge is separate and apart from the Cherokee Nation.
Certainly, a district court judge for the United States is an entirely different job than the job of an advocate. As Attorney General, of course, I was an advocate for the tribe's legal position and for its rights. Like all attorneys, I would advocate on behalf of my client with all the intellect and all of the strategic thought I could put into it on behalf of the nation. For a federal district judge, it's an entirely different job. The job is to look at all the cases that come before you impartially and fairly, and looking at everything on their own terms, and then applying the facts to the law. And it's a much different role entirely.
Thank you very much. Judge Manglonia, I want to pronounce your name correctly. Is it Manglonia?
Manglonia, yes, with the glotte.
Close now. You had a range of experience as a litigator and a jurist, and spent your legal career in the Northern Mariana Islands, including a previous appointment to the bench to which you've been renominated. I want to make a note of this fact, that after the island was hit with devastating typhoons in 2015 and 2018, you kept the courthouse open to ensure the crucial work of the judiciary would not be interrupted. Your judicial chambers were awarded the 2019 Director's Award for Extraordinary Action from the Administrative Office of the U.S. Court. How have your experiences equipped you to continue serving that unique need in the Northern Marianas?
Senator, the two super typhoons that hit Saipan, with the distance to receiving the help, was truly challenging. I was very grateful for the support from the administrative office, as well as my neighboring district in Guam. As I mentioned, the experience that I've gone through made me stronger in regards to being creative in how to deal with challenges. And I actually, from our initial experience in 2015, some of the other districts that then suffered other natural disasters in other parts of the country were able to avail of some of the lessons that we learned. And I believe all this experience is going to ensure that should there be another disaster or calamity, I will be so well prepared to maintain or keep the courthouse doors open to ensure that people's constitutional rights are still addressed.
Well, congratulations to you on that effort.
Thank you.
Mr. Russell, while reviewing your record, I noticed you've been representing U.S. purchasers in a putative class action against the manufacturer of a breast cancer drug called Herceptin. The plaintiffs in the suit contend the company falsely labeled vials of the drug so that the purchasers regularly received less of the active ingredient than they thought they were receiving. Can you tell us about your work in that case and what specific claims the class is raising?
Senator, the plaintiffs in that case, it's a putative class action. It's also a multi-district litigation case. And the claims are breach of warranty, fraud. There are several different claims relating to the lack of Herceptin that is showing up in the vials over a historical period of time. And so the claims are that the doctors' offices having to administer the Herceptin were required to open additional vials at cost and loss each time that they administered Herceptin to a breast cancer patient.
I'm a little familiar with that issue because we've had the opposite be the case as well, that drugs are put in containers far greater than necessary for the ordinary dosage, and many of these very expensive drugs end up being surplus and thrown away. So labeling and handling and bottling is a critical element in making sure that the American consumer is treated fairly. Thank you very much. Senator Graham?